Hello, everyone. Good afternoon. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. Today is our next live stream where I discuss immigration topics. Today's topic is asylum and preparation for asylum interview. Part of it also refers to preparation for the asylum hearing, individual hearing in immigration court. And after I discuss this topic, I will also answer any questions that our audience members have. You can post your questions in the chat section or in our Facebook channel. I believe this live stream is being streamed simultaneously on our YouTube channel and our Facebook page. Please subscribe to our channel. Please like our page. And if you can, please also like this video. I would greatly appreciate this. If you find it useful and helpful, I appreciate if you like this live stream and if you also subscribe to our channel. So again, please post your questions in the chat section. I will do my best to answer all of the questions. But I want to briefly talk to you about preparation for asylum interview or for your individual hearing in immigration court. So the first advice I have is that you need to make sure that you have the attorney who's representing you, who's going to prepare you thoroughly for the asylum interview or for your individual hearing, for your trial in immigration court. Your attorney who prepared your asylum case, as long as they're competent, as long as you feel confident working with them, they're the best attorney to represent you in this process. Now, if you're not confident, if you hired an attorney who may have just helped you with the forms, they're not answering your calls, they're not communicating well with you, you're always free to replace your attorney. And if you're interested in working with me, I've been handling asylum cases for more than 16 years, and I'm a licensed attorney. I'm a founder and owner of IS Law Firm. So I'll be happy to help you, and you have the contact information in the chat section. But for the interview, so what I usually recommend to do is to read and review all of the documents, all of the forms and documents you've provided to the asylum office or to the immigration court prior to your hearing or interview. Now, do it several days before. So in case if you find an issue, then you can address it with your attorney, or you can prepare to address it in your immigration court hearing or your asylum interview beforehand. But do not study, do not try to memorize everything you wrote in your declaration, and do not plan to just retell your story based on your declaration. At your asylum interview or in immigration court, you will be answering questions. Your role is to simply answer the questions truthfully, honestly, directly, on point, and briefly. So those are the rules. You want to be as brief as possible, but you want to give complete answers. So you don't want to volunteer extra information or say anything extra other than answering the question. So focus on the question, but you also want to make sure that you provide complete answers. So when somebody, for example, asks you the date when you entered the United States, do not just give them day or the month or the year. Make sure you give the complete answer. Now, this is an example. And then don't add where you entered the United States or what kind of visa you had. Again, it's not going to hurt if you add, but don't do it. Let the person who's asking you these questions, whether it's your attorney in immigration court or judge, or whether it's the asylum officer, let them ask you the next question. If they need to know, they will ask you what type of visa you entered with or how and where you entered the United States. So this is an example. So make sure you give complete, brief answers. You don't have to talk about anything else other than answering questions. Now, what you should do is you should always wait for the question to be complete and over. So make sure that the officer asks the question, you understand the question, and the person asking you the question finishes asking you the question before you answer. Just a quick answer, or think about the question, but quick answers do not impress anyone. So make sure you wait until the question is over and then you answer the question thoroughly, again, completely, but also briefly without any extra information. Do not interrupt the person. Be very respectful to the officer, no matter how ridiculous the question sounds. You have to understand some of the parts of your case may be very straightforward and simple to you, But to the officer, to the immigration judge, they may not know anything about your country, where you're from, where you're asking for asylum from. So be respectful, no matter how dumb is the question, or how ridiculous it sounds, or how obvious is the answer. Just answer respectfully. Some of the questions that the officer will be asking you, or the government attorney, so to speak, prosecutor in immigration court will ask you, they will sound very obvious, but they have to ask those questions from everyone. And some of the questions may sound insulting to you, but don't be insulted. You need to answer them anyways, and they have to make sure that they ask those questions from you. Now, one of the important points for preparation in asylum interview or for immigration court, you have to decide whether you need an interpreter, whether you need a translator who's going to translate what you say and translate the questions to you. There is a misperception that there is these wrong rumors that you are supposed to have a translator. It's a good idea to have a translator. If you go to the interview without a translator, they will suspect, or that you may not be able to express yourself. And that's not right. That's incorrect. If you can understand what I'm telling you now, if you're watching this live stream, these instructions or this video in English language, you understand what I'm telling you. And if you can express yourself in a simple language, you don't have to use any legal language. You don't have to use complicated words. If you can express yourself, you don't need a translator. Here's the problem with using a translator. Again, if you don't understand English, or if you know somebody who's going to the interview and they don't speak fluent English, they don't speak or understand English, then obviously they need a translator. Okay, I'm not recommending to go without a translator if they don't understand or speak English. But if you know the basics enough to be able to understand the questions and to answer the questions, it's best to go without a translator. And the reason is because during the translation, the tone of your answers sometimes get lost. It's a different tone. The translator is not going to answer in the same tone, in the same way that you are answering the questions. The words that you use may be important, so the translator may not be expressing the same words or using the same words, and some of the words are lost in translation. So for example, you can give a long answer. For example, if a question is asked from you, my recommendation is always, if you don't know something or if you don't remember something, say I don't know or don't remember. But if it's something very important and you vaguely remember it, you want to highlight that you're not sure about it because you don't remember exactly, but you think it was on this date. For example, if somebody's asking you a date of something that had happened to you. So when you give that answer in your own language, you're going to say, I'm not sure exactly, but I think it was in the year of 2021 on December 5. The translator, in many circumstances, will miss that first part, will not translate that I'm not sure, I remember exactly, but they'll just translate, it was on December 17, 2021. Now, you lost the important part of what you said, because what you said doesn't matter as long as the translator doesn't translate it to the judge or to the officer. Then what you said has no meaning whatsoever. So that's why it's very important, I think, is to not use a translator if you can express yourself, because nobody can answer those questions better than you. Certainly not the translator who has no idea about your case. Now, the other problem with the translator is that the interviews and the hearings in immigration court become very chaotic when you use a translator. First of all, it's going to take twice longer for your hearing, approximately twice longer, because everything you said has to be translated. Everything they ask you has to be translated back and forth, and things get lost. It becomes a little difficult. The judge may not understand the translator, or you may not understand the translator. So it's going to take a lot longer, and the officer and the judge may get agitated. They're not supposed to. They have to be patient, but they're human beings. So in reality, it happens. So if you can avoid using a translator, then do so. Even if you have a translator at your hearing or an immigration or asylum office, you can also tell the officer that, officer, I can answer all the questions. I can, express myself, and the translator can assist if there is any misunderstanding. Some of the judges and officers prefer that. They appreciate it. So, you do your best to answer. And especially if you spent many years in the United States, which a lot of asylum applicants do, before they have interview or before they have immigration court hearing. It's respectful. If you know English, if you can communicate in English, then do so. It also sounds strange if you spent 7 years in the US and you still don't speak English. I'm not saying you need to. There is no official language in the United States, and you're not forced to know the English language. That's why the courts provide you a translator. You don't bring your own translator. But that's an important point in preparing for asylum interviews and asylum hearings in immigration courts, is the decision about whether you should have a translator or not. So consult with your attorney as much as you can about this. Again, there is no complicated language needed. In fact, even if you can speak fluently English and you can use, legal language and so on, don't do it. Speak in very simple language. Do not make any conclusive statements. Your role at your interview and your hearing is to just answer questions using simple language. You don't want to say, for example, if they ask you a question, have you been threatened? The answer is yes. If you have been threatened, then you say, yeah, I've been threatened. And then when they ask you who threatened you, what did they tell you, you have to break it down. So instead of saying conclusive statements that they pressured me into doing something, what does pressured mean? So you want to break it down. You want to use simple language. You can say, they told me that they'll fire me unless I sign on this paper, right? So that's more exact. That's more simple language rather than saying they pressured me to sign this paper, because pressured is a vague term. Pressure could mean many things. Similarly, you don't want to use the words like persecution, right? Persecution is what you and your attorney are trying to prove to the judge or to the officer that you would suffer. There is a reasonable chance of persecution if you return to your country. So you don't want to use the persecution in given. So what will happen to you if the officer tells you, why did you apply for asylum? The simple and easiest answer, again, I'm not saying you have to use my words, but if you are afraid to return to your country, then the first question may be, why did you apply for asylum? You want to say, because I'm afraid to go back to whatever country I am from. So then the next question is going to be, who are you afraid of, or what you're afraid of? Why do you think this will happen to you? Then you can explain that, if I return, or let's say if they're asking you, what will happen to you if you return to Russia, right? For example, if you're from Russia. So you say, if I return, I will be persecuted in Russia. That's wrong. Don't say that. Persecution is the conclusion to which the officer or the judge has to reach based on the facts that you provide. So you want to give facts. You want to give, not only facts, but also your opinions, your thoughts, but you want to use simple language, not the conclusive statement. So rather than say that if I return to Russia, I will be persecuted, I will be subject to persecution, use simple language that you would use in communications with your friends. So if your friend asks you, hey, why are you here? Why can't you go back to Mexico, for example? You're not going to say, if I return to Mexico, to your friend, you're not going to say, if I return to Mexico, I will be subject to persecution by the government authorities, right? That's not how you communicate. So you say, if I return to Mexico, probably the drug cartels will beat me up, arrest, or the drug cartels cannot arrest me, but the Mexican government will arrest me, or whatever will happen to you. They'll torture me, they'll beat me up, and so on, or they'll kill me. So use those simple, rough, words that you use in your simple language. Do not use any legal terminology or conclusive statements or any complicated words. Use simple language. Some of the things that catch asylum applicants during asylum interviews off guard, some of the things that the officers use as trick questions, or the officers in the immigration court, the prosecutor in the immigration court, they often use this as trick questions. They ask you question, did you provide any false information when you applied for a visa? So at one point you entered the US, let's say with a tourist visa, student visa, and so on, and then you applied for asylum. So they ask you, did you provide any false information? And if you did, you have to admit, first of all, obviously you don't want to lie in immigration court or an asylum interview, but even if you did lie previously at the consulate, that's a trick question. That's not going to cause your asylum to be denied. A lot of people get nervous and they say, no, I didn't lie. I was coming here to study. But in reality, they did not. They were just fleeing from persecution in their country, and they provided false documents, showing that they're employed or they're coming here to study. But the goal was to escape from, certain death, potential, arrest, detention, risks to their safety, well-being, or freedom, and they fled to the US, and that's why they used fake passport or fake information and fake documents. So if that's what happened, admit it. And the good news is that it's not going to cause the denial of your case. There is a precedent case law which says that even if you lied at the consular interview, now, again, I'm not advocating for lying to do that, or using fake passports, or using, illegal ways to enter the US. But but what I want you to know, that there is a case law that if you lied, if you presented false documents and so on, that alone cannot serve as basis for denial of your asylum, because it's presumed that somebody who's trying to escape from, risk of death, arrest, for their safety of themselves and family, they'll use different means. Some refugees just, jump over the fence and come to the countries where they're asking for asylum. So under the United Nations Convention, that is not the basis for denial of your asylum. But if you lie about it now during your asylum interview, if you tell the officer, no, I didn't present any fake documents and so on, you're lying about it now, about the fact that you lied before. That is basis for denial of your asylum, because now currently you're in the United States, you're not doing it for your safety or well-being, you're basically misrepresenting information today. That damages your credibility, which in turn can cause your asylum case to be denied. So that's very important to know. A lot of people that, self-represent, or even some attorneys, don't provide all this thorough preparation for the asylum interviews or hearings, and some clients get caught in that trap and they get nervous. And I understand. I'm not blaming, I'm not judging anybody morally for, saying that, no, I'm a truthful person, I never lied to the US government. But, the reality is that if you do, then during this time, your asylum interview or hearing, that's gonna cause serious injuries for your case. So, as I said, my name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. I'm a member of American Immigration Lawyers Association with over 16 years of experience representing clients in immigration matters, all kinds of immigration matters, including asylum cases, representing clients and refugees from all over the world who come to the United States to ask for asylum. During the previous live streams, we have these weekly live streams every Thursday at 12:30 p.m. During the previous live streams, I talked a lot about CBP 1 process, how to enter the United States through Mexican border legally, lawfully, through this orderly process that the Biden administration created. And that's very important to be able to use that as soon as possible. If you have basis for asylum, if you have fear of persecution in your home country and you want to come to the US to apply in orderly way for asylum, for protection, there is an orderly process. Use that, utilize it, come here, bring your family, and as long as you have basis for asylum, you will be allowed to enter the US, and you can have your work permit, social security number, driver's license. You can get those immediately by filing those documents and requests. And then you can apply for asylum. You will be given opportunity to be heard in immigration court, or potentially even with the immigration office without court proceedings. And you will be granted asylum if you have basis and you're able to prove, to demonstrate the basis. So use that. This has been, we've been talking for several live streams, weekly live streams. We were talking about CBP 1, and that's very important topic. That's very hot topic. I just had a consultation right before this live stream. I was on the phone on consultation with a client who entered the United States through CBP 1 just 6 days ago, actually 5 days ago, on the 21st. He described the process, this is a fresh information about CBP 1. So he described the process. He entered, he came to Tijuana and stayed there for 13 days until he was called. He received a notice of the appointment with the CBP officer at the southern border. So he spent 13 days to wait for that appointment, which is great, which is amazing. I mean, it's never been that easy. And then he was asked just basic questions. He arrived at 12 p.m. to that appointment, and by 8 p.m. he was already in the United States. He was free to go. He had all his documents and his passport, and he was given this notice to appear in immigration court. We just checked the system. He doesn't have the court hearing yet, but it will be assigned within a month or so. But in the meantime, we'll be preparing and filing his asylum application, declaration, and all that with the USCIS affirmatively. And then we can file it with the court if the court eventually opens his case, which is hopefully going to be soon. But the bottom line is that the CBP one is still working. As I said, just 5 days ago, this individual entered the US with all this process. Everything went smooth, very well. He was asked just basic questions, and everything worked out. So I will move on to answering questions from our audience. Please post your questions in the chat section or in our social media. If you're viewing this on Facebook, you can post your questions there. And again, for anybody who's watching us on Facebook, please press like, please like our page. And anybody viewing this on YouTube live stream, please also press like. I'd greatly appreciate that. If you find this useful, please press like and please subscribe to our channel. It's very important because in our channel, obviously, if you're viewing this this live stream, you might be interested in asylum, in applying, or you have a pending asylum, or you have some friends, relatives, somebody who's planning to apply for asylum. Please invite them also to this channel and tell them that this U.S. immigration lawyer every Thursday at 12:30 p.m. Eastern Standard Time, which is Washington, D.C. time, where we are, this attorney answers all of the questions, immigration questions, free of charge, and I'll give very thorough, detailed answers. If I'm not able to answer all of the questions, I will still answer down the road in the comments. You can also post your questions in the comments if you are watching this video after the live stream is over. But if you subscribe to our channel, you will also receive notifications of all these live streams, and you will also receive notifications of the videos that we post frequently, where I provide instructions about different steps, not only related to asylum, but to any kind of immigration matters. EB-3s, employment-based, talent visas, student visas, work visas, green cards, diversity visa, lottery, family reunification, family petitions. So all of that, anything you want to know, if you have a green card, how much time you can spend outside of the U.S., whether you need a reentry permit, do you have to live in the U.S., how much time you can be outside or inside the US. So all of that, your naturalization application, you can find videos there. Again, please press like, please subscribe to our channel, and I will move on to answering your questions in the chat section. And if you have any questions, please post it in the chat section. So I'll go through the audience questions first, and admin also posted some of the questions from social media accounts. Then I will go there. Eat at sex 3 years ago. Okay, I don't understand this question. Adus is asking, June 29, started opened app EAT at 6 p.m. 3 years ago. I don't understand what that means. User 1905 says, hello, sir. How are you? Thank you, user 1905. I'm good. The question from user 1905 is, I have a quick question. So if a person has a green card, just 1 second. Let me see the admin. Okay, please repost your questions. Some of the questions, I'm told by admin, some of the questions you posted disappeared from chat. I do see lots of questions in the chat section, and I will do my best. I see user 1905, you posted lots of questions piece by piece. I'm not going to be able to answer all of your questions. I want to make sure that every user has opportunity to post a question and to get answer, every audience member. So I will answer this question that you have. I'll move on to others. As if I have time, I'll come back to your questions again. So your question, user 1905, is, so if a person has a green card based on asylum, also valid home country passport, can she travel to third country with her home country passport? Would it cause any reentry or naturalization issue? Have you experienced it? Thank you. Yes, we have experienced that many times. So I want to demystify about individuals who got asylum or green card after asylum, based on asylum, and being able to travel using their passport, or even traveling to the same country where they got asylum from. So there is this gray understanding and there is mystery. Somebody says you can, somebody says you cannot. Let me try to break it down. So if you got asylum from country, let's say from Mexico, and you're now in the United States and you got asylum, you applied for green card, you got green card, you can still have your passport, right? Okay, we're bringing in Mexico as an example. So you got your Mexican passport. Can you use that passport to travel to a third country? The answer is maybe. Is it advisable? No, it's not a good idea. The reason being is, if you're using a Mexican passport as asylum to travel outside of the US, even though you have green card, which will allow you to enter the US, but if you use your country's passport, you're subjecting yourself to the jurisdiction of that country, because that third country, wherever you're traveling, is going to treat you as a citizen of the country that you're from, because you're using their passport. Now, when you got asylum, even after you got green card based on asylum, the United States gives you this refugee travel document, which substitutes your passport. And in that document, the United States announces to the world that you're being protected. You're subject to the US, you're subject to US protection. So it's a little bit, excuse my word, it's a little bit stupid to use your passport from the country from which you asked asylum and not utilize the US provided protected, refugee document, where the rest of the world is going to treat you as somebody who's under US protection. Now, if you use your country's passport, go abroad, and whatever the country you're in, you'll have some issues. They're going to treat you as a citizen of the country you came from. Or if they have extradition treaty, they're going to extradite you to that country because they see you as a citizen. That's how you entered. You didn't enter with a refugee travel document. You entered as a citizen of your country. So that third country, and there is no blame on them, they're going to treat you as a citizen of the country that you use the passport of. So don't do it. There is no reason to do it unless you're doing it just to avoid getting a visa to that country, or maybe you're going to a country like, for example, United Arab Emirates, right, which is not a signatory to the Convention for Status of Refugees, so they may not be accepting travel document. You have to use it. Then you have a good reason to explain in case if this comes up at your citizenship interview. So when you apply for citizenship, the USCIS is going to go back and review your entire history of your asylum case, your green card case. They'll again reconsider all of the applications you filed, not your entire asylum case declaration, but they'll compare to what you wrote in your declaration, what you filed in your green card application, in your asylum application, in the forms, and what you filed, prepared, what you provided in your citizenship. Because this is the last chance technically for the US government to catch you lying or misrepresenting information and so on. So very thorough preparation for citizenship is important. And they will review your travels. After you got your asylum, they will see if you traveled to your country of persecution where you said that you were afraid to return to after you got your green card. So if you do, they'll ask you questions. It's not going to automatically terminate your asylum. That's the wrong part. A lot of people think that, if I got asylum from whatever country you got asylum from China, and I went to China, that will immediately cause my asylum being terminated. No, that's not going to happen. When you file for citizenship, if you have a green card, or when you return from that travel, you may be asked questions. If you have good, strong, legitimate reasons and explanations, then you're not going to lose your asylum status or your green card. Okay? I had a client who went to his country 7 times before he became a citizen. During the citizenship interview, this question came up. We explained this gentleman had his minor child. He was separated from his wife. Wife had the custody, and he had his minor child, his only child, his daughter, and he had to travel to his country. This was in Azerbaijan, and he had to travel to Azerbaijan to see his little child multiple times. And his basis for asylum was not on political reasons. He wasn't claiming that the government is after him to arrest him or to detain him. So his brief travels did not cause his asylum to be lost. He got naturalized successfully, and now we even brought his child to the US. She's now a little older and goes to school here. So what I'm trying to say is that to answer this question very thoroughly, and this is an important point, that's why I'm spending so much time on answering this one question, is that if you got a green card based on asylum, do not use your country's passport. Just put it aside. I'm not saying shred it or throw it away. Maybe one day things will change in your country and you will be able to go back. So you may use that passport. But other than that, I'm sorry, 1 second. Okay. So if that comes up, then you may use it, but don't use it. Do your best to avoid using your country's passport. And that may become an issue in your naturalization case. Okay, so Adus Abu Bakr is asking, immigrant visa, non-immigrant visa, for not difference. The question is, what's the difference? I assume the question is, what's the difference between immigrant visa and non-immigrant visa? So as the name suggests, immigrant visas are visas for those people who want to immigrate into the US. Those are basically green card application for permanent residency in the US, but not in the US. It goes through the US consulate. That's why they first issue a visa. Well, to understand the difference, you first understand the difference between visa, status, and lawful presence. So in the US, you don't have a visa. While you're in the US, what you have is status. The visa in your passport is irrelevant while you are physically in the US. You either have status or you don't have status. Visa is a document in your passport is only used to enter the US. So once you enter the US, the visa is irrelevant. Okay, it's only relevant as to what status you will get once you enter. For example, if you have a visitor visa in your passport, which may be valid for 1 year or so, that means you can enter the US anytime during that 1 year. Once you enter the US, they give you a status of 6 months in the US. And that visa is irrelevant. Even if it expires during those 6 months, you're still good, you're in status. So non-immigrant visa assumes that you're not entering here as an immigrant. With the immigrant visa, when you enter the US, you become immigrant, meaning you become a permanent resident. So the status that you acquire, you attain upon entering with immigrant visa is permanent residency, also known as green card. But the status that you get with entering with non-immigrant visa are all the types of statuses which are not permanent residency, which includes, student visa, tourist status, student status, O1, work status, so those statuses. And that's why if you apply for a green card inside the US, the process is called adjustment of status. It's not called visa or change of visa or adjustment of visa. It's called adjustment of status. But if you apply for permanent residency through US consulate, because you're abroad to enter, you need a visa. That's why it's called immigrant visa. So that's the difference between non-immigrant visa and immigrant visa. All right, the next question is, okay, Karim is asking, could you please provide best strategy to expedite individual hearing in court? Planning to get earlier date because of mental illness, for what I should pay attention in order to succeed with motion to advance. So as you wrote, motion to advance, I assume you already know, you probably consulted with someone. So the best strategy to expedite your individual hearing in immigration court is to file a motion to advance. That's the motion called is motion to advance your individual hearing. Now, before you file this motion to advance, there is another step that you could have taken, or you can still take if you have a master hearing date scheduled, which, some people have master hearing scheduled in 2 years from now. To make as you know, master hearing is your preliminary hearing. Then you have individual hearing, which is the final hearing. So if you file a motion to advance, but you also have master hearing, the master motion to advance is not going to eliminate the master hearing. The judge cannot advance your individual hearing because you don't even know what the date of individual hearing is. You didn't attend your master hearing yet, where you have to enter pleadings, you have to discuss the details of the case, not details, but like procedural matters, and then schedule individual hearing. So what you can do even before motion to advance, you can file a motion to waive the master hearing, so the judge doesn't have to wait. You don't have to wait for that happen first. You can go immediately to scheduling individual hearing. But together with that motion, you also have to file what's called written pleadings. What it means is that basically whatever would have happened at the master hearing, at that preliminary hearing, orally, when you go there, you have to orally tell the judge, you or your lawyer will tell the judge those procedural aspects and their pleadings. Now, what you do is you provide it in writing and you tell the judge, we don't need to wait 2 years for the master hearing to schedule the individual hearing. Let's waive it. Here's my written pleadings, everything that I'm going to say at the master hearing. Please drop that, take it from the docket, from the calendar, and let's schedule individual hearing at the earliest date. In that case, you can actually combine the motion to advance. And in the same motion, you can also say, here are the reasons, here's the explanation why I need this hearing earlier, as soon as possible. So if you have a window, my case is all ready, everything is good to go, I'm going to take the first available date. So that's the best strategy. Now, if you already had the master hearing, then as you indicated, put the motion to advance. But the strategy in motion to advance, in convincing the judge to schedule your date earlier, there are multiple things that you need to do. Number one, you need to make sure your case is complete, meaning you have your declaration, you have your forms updated, you have country conditions reports. If you're asking asylum based on particular social group, you have memo submitted for your particular social group definition. Your lawyer will do it if you have a lawyer, which is a good idea if your case is in immigration court. So you want to make sure that everything, all the evidence, and you want to make sure that your case is complete. Because if you don't have complete case and you're saying, please schedule my individual hearing as soon as possible, there is no motivation, because now that they will schedule, you or your lawyer will probably tell them, oh, that's too soon. We don't have the case. We need to supplement, okay? If you're asking to advance your hearing, or this also refers to your asylum interview. If you're asking to expedite your asylum interview because you've been waiting for years, now something happened, you have an emergency situation, you have, severely ill family member, parents, or your family is there and you're here, there is threats, there is issues, some reason. If you're asking to expedite your case, you need to first make sure your case is complete. And in that request for expedite, you have to actually state that affirmatively, that my case is complete, I've submitted everything, we're ready to go. Tomorrow, schedule my interview or hearing tomorrow, we're going to show up. So that's what you need to indicate. Then the judge and the officer in the asylum office, they're excited because they see they understand your situation, and they see that you're honest, you're sincere about this. You're not just randomly throwing this motion or request to expedite whatever happens. No, you have the case complete, everything is ready. And if they have a window open, and if they offer that window to you, they know that you will take it. We had a case where we filed for a motion to waive master hearing. As soon as we took the case was just sent to the immigration court, referred from the asylum office. And as soon as the client hired us, we filed a motion to waive with a motion to advance and filed any supplemental documents. We had the judge set our individual hearing after 2 weeks from that motion, just 2 weeks. Imagine, his master hearing would have been, a year or two later, and then individual probably another. So we saved this client about 4 years by submitting everything all at once. So make sure to do that. That's the best strategy. The next strategy is provide details as to why your case needs to be expedited. Don't just file an expedite request because you want to be before others, okay? The reason why your individual hearing or your asylum interview is taking so long is because there is a backlog. There are people in line. You're waiting. I always tell my clients, imagine you're at the airport, there are 500,000 people in front of you, and that's how many cases are in the backlog. In immigration courts, I believe it's over 1 million cases or so. So imagine that many people are in front of you and you're yelling to everyone, please move everybody aside. I want to go first. If you do that, you better have a good damn reason that you need to provide. So do that, and then your chances of getting your case advanced, your hearing advanced, is going to be much faster, much higher chances. Okay, so provide all that. Now, the next strategy that your lawyer can use in immigration courts, that doesn't work with asylum offices. The immigration courts, your lawyer can have contact with the judge's clerk, right? And your lawyer can say, okay, call the clerk. They're fine. A lot of them are very responsive. They communicate. Some of them communicate with me via email as well. They're very responsive. I can call them and say, here's the situation, clerk. I filed a motion to advance. This is what my client has. That's filed to provide to comply with the formality of asking to expedite the hearing, but help me out if there is a window, because you as the judge's clerk, you know the best. If maybe there is a hearing tomorrow and it was canceled because the applicant got sick, or they moved, or they canceled, or the government agreed to dismiss their removal proceedings. If there is such a window, dear clerk, please let me know. We'll take it. That way you don't have to scrabble through your cases and decide which case, or keep calling everybody and saying, who will take this window so it does not get lost, or it doesn't just stay empty. So your lawyer can do that, can communicate with the clerk. And finally, what I have seen and we have done in the past is communicating with my colleagues through American Immigration Lawyers Association, where we discuss that, okay, I have a client who has a hearing date coming up in 2 years with this judge. If anybody has a client who is not objecting, doesn't mind moving their case to a later date, we can just basically swap. And there are lots of individuals, asylum applicants or individuals in removal proceedings, who would prefer actually their hearings to be later than sooner, because they are either, like, for example, they're dating someone, they're hoping to get married, maybe that will work out, then they're going to get green card, maybe they don't have strong asylum case, or maybe they're waiting to qualify for some other immigration benefit. So for one or other reason, they may want their hearings to be delayed. So we communicate among lawyers and we decide, okay, if we can swap, let's talk to the clerk or the judge and say, can we do it? As long as the judge doesn't object, which they usually don't. They don't care. I mean, unless the other guy has been delaying their case for so long that the government may object. But if the judge and the government, again, they also don't care. I mean, which case comes first? Usually they don't, as I said, unless for specific circumstances. So they agree, and that's another strategy that your lawyer can use. Next question, Amin asks, can you file for work permit before asylum application? The applicant came to the US through CBP-1. Please answer. Okay, I will answer, Amin. Yes, the answer is yes. Any parolee into the US, someone who's paroled, can apply for work permit in the United States, okay? That's the process. That is applicable to all parolees. There is actually a special category. I don't remember the number. It's C18 or something like this. But you can look it up. So every parolee can apply. Now, CBP-1 parolees are specifically allowed to do it. And I mean, not everybody, again, elder parolees, somebody who's paroled into the US, they're allowed to apply for work permit. But as a matter of policy, the USCIS treats CBP-1 applicants as a priority and tries to approve their cases much faster. We have clients who got 30 days, 60 days approval for their work permits after filing, after entering with CBP-1. And the reason is that because there is specific instruction from Biden administration, right? They're the ones who decide what CBP or what ICE, Immigration Office, or USCIS does. So they specifically instructed to do everything they can to make the process much simpler for CBP-1 entrants, because they want to encourage, the main priority, to encourage the use of CBP-1, entry into the US using the CBP-1 app, because CBP-1 app was created for the purpose of creating order at the southern border, so people don't illegally cross, they endanger themselves or cause problems for the CBP and immigration customs enforcement, trying to run around the desert and finding undocumented aliens or minor children crossing, or drug cartels helping them to do that, endangering their life, well-being. So they created the CBP-1. That's why Biden administration is doing everything they can to push everyone to use this orderly process. And I applaud the Biden administration. This is great. This is a great job. But of course, for the safety and well-being of the United States as a US citizen, I don't want this to be forever. As an immigration lawyer, that's good. Asylum applicants can come in, but there has to be some kind of control down the road. And that's the purpose they're doing. They're not doing it as open-ended. And the reason why I'm saying, somebody can say, oh, you're an immigration lawyer, you're advocating for the end of CBP-1. No, I'm not. What I'm advocating is we shouldn't advertise it as a process that's going to be open forever. And that's not what the Biden administration does. That's not what the DHS Secretary Mayorkas says during the congressional hearings. The official presentation of CBP-1 answer to this is that we're doing it for the time being to avoid the disorder at the border. But then once we do find a way to avoid, these illegal entries where we don't even know who's entering, at least through CBP-1, we're checking their passports. We know where they're from, who they are. We check them against the background check in the system to see if they have, previously violated the U.S. laws or committed crimes. They do background check, biometrics check. They do name check to see if this person is a, member of special security forces or foreign governments who, enemies and so on, somebody from Russia who's coming here as a spy. They do these checks as much as they can within reasonable degree. But so that's better than somebody entering here illegally, but it's not going to stay open forever. The Republicans are already suing in the federal courts. This is going to end at one point. As we all know, the Supreme Court consists of judges which were appointed primarily by conservative presidents, including Trump, which are very anti-immigrant, which have strong anti-immigration sentiment. Not all of them. I mean, some of the conservative judges are just being reasonable. But so anyways, so if you have someone who wants to enter the U.S., to apply for asylum, okay, I'm not advocating, or the government doesn't advocate use of CBP-1 just to enter the U.S. for economic reasons. You will be placed in removal proceedings. Everyone who enters the U.S. with the CBP-1 is placed in immigration court. They have to appear and prove their case. Otherwise, they will get an order of deportation, order of removal that will ban for the next 10 years entry back into the U.S., right? And then it can also carry criminal penalties. The Biden administration began enforcing criminal penalties for someone who enters the U.S. illegally. So with CBP-1, they also started actually tightening the immigration asylum laws. The Biden administration enacted transit ban, which creates a presumption that you are not eligible for asylum if you enter the U.S. through any other means other than CBP-1, and you went through a third country, which naturally everyone does, right? At least you have to come to the U.S. border, which is with Mexico or Canada, and you went through, or might be the ocean port of entry through U.S. territory or waters, but you're going to go through a third country. And if you did, there is a presumption that you should have applied for asylum in those countries. That's called transit ban. That's going to be a very high burden to overcome unless you used CBP-1. That transit ban doesn't apply to CBP-1 entrants. Okay. Let's see the next question. So everyone, whoever has any questions, please post in the chat section. I will do my best to answer as much as I can. And if I cannot, then we will go through this during the comment section after this video is posted. Again, for anyone who joined, my name is Ismail Shahtakhtinski. This live stream is a weekly live stream, which is simultaneously streamed on our Facebook page and on our YouTube channel. I greatly appreciate if you press like, whether it's on Facebook or on YouTube. That helps us. If you find this video or this live stream where I answer all the questions of our audience, if you find it useful, if you press like, please press like. If you do so, I greatly appreciate. That's your feedback. Or if you want to give me any kind of other feedback, if you think that I'm answering questions too thoroughly or too short, or if I'm giving wrong answers, or anything you don't like about this, please also post. So you either like it by pressing like, or you don't like it, then please tell us why you don't like it. I'm kidding, no pressure. You want to press, you want to like it or not, it's up to you. You want to subscribe to our channel or not, it's up to you. No pressure. My goal is just, I enjoy giving these answers. I enjoy talking about this because immigration is my passion, especially about asylum cases, helping out refugees and so on. So I enjoy these videos. Sometimes when marketing team says, well, you have 2 live streams every week, right? I have a Russian speaking live stream for all the clients from, post-Soviet bloc, from Eastern Europe, with the situation in Ukraine, with the war aggression of Russia against Ukraine. There are lots of refugees coming from there. So that's why I have weekly live stream on Tuesdays at 2 p.m. Eastern Standard Time, Washington, D.C. time for Russian-speaking audience. And then I have this 12:30 on Thursdays for English-speaking audience live stream where I answer all these questions. I enjoy doing it. That's very rewarding experience to be able to help, even if it's just by answering the questions. Now, if you do decide you want to work with our firm, then we kill 2 birds with 1 stone, right? Then we also do marketing. You are hiring our firm that compensates us for the time that we're spending for the work that we do. If you don't want to work with our firm, that's great too. Feel free to post your questions. I will still answer your questions. Even if you have a lawyer, immigration lawyer who's representing you, ask me your questions. I will do my best to answer as much as I can. Okay, so next question. Joe is asking, I came to USA in May, I assume May of this year, and my status is expiring November 2023. So May 5, 6 months. So I assume you entered with a visitor visa, which gives you 6 months. So that's why your status expires in November. I would like to apply for asylum. When would be the best time to apply, considering that if asylum is rejected, I would be able to appeal? That's a great question. I'm glad you asked. I'm going to give you a very detailed answer, and that's very important for everyone to understand. So you entered the U.S. with a tourist visa. You have 6 months of stay. when you should apply for asylum, as soon as possible. All right, preferably the day after you entered the US. Apply for asylum. If that's why you entered, if you have basis for asylum, file for it as soon as possible. The second part of the question is, considering that if my asylum is rejected, I would be able to appeal. And that's where many applicants, individuals, paralegals, people that don't fully understand, or immigration lawyers, some of my colleagues don't understand this. That's where many people make mistakes. So there is this wrong perception that if you file for asylum, if you get your asylum interview during your valid status, right? You have, let's say, valid student status or tourist status or work visa, and before it expires, before your status expires, you filed for asylum and you got your interview, there is a misperception that if your asylum is denied, you lose your chance to appeal. That's wrong. No, you don't. You still have a chance. That chance is never going to be lost. You will have it in your pocket. And it's not appeal. What by appeal you mean, Joe, is that having an immigration judge to consider your case de novo, meaning from all over again. So that chance is never lost. If you have your asylum interview while you are in valid status, right? You still have your status and you got your asylum interview. That's much better. And here's why it's much better. So, well, to explain here's why, let me first explain what if you don't have a status. So if you don't have a status by the time of your asylum interview, you go to the interview. If the officer gives you asylum, great, you got asylum, the result is great. If the officer doesn't agree you get asylum, they'll refer you to immigration court. And then you will be able to present your case to the immigration judge. That's automatic. They'll just send your case to immigration court if the officer or supervisor of the officer doesn't believe that you deserve asylum. And then in in court, you have to present your case. So, but what happens if you do have a status and the officer doesn't believe you deserve asylum? They're not going to send your case automatically to immigration court. And that's the important part. They're not going to send it automatic, but you will have that chance. It's in your back pocket. You decide when your case wants to go to immigration court. And here is how. So if the asylum officer believes you don't deserve asylum, number one, if you have a status, they have to give you what's called notice of intent to deny. We call it NOID, N-O-I-D, in which the asylum officer, if you have a valid status, the asylum officer has to provide you thorough and detailed explanation about the issues or the problems this officer has for granting you asylum. And that officer has to give you at least 30 days to respond to that notice of intent to deny, to address those issues. So you get a second chance, not only with the immigration court, but you also get a second chance with the same asylum office, where you can convince that officer or address those issues. Maybe the officer didn't do a good job during the interview, didn't ask you questions, and then presumed things about you, and now says, well, I'm not sure you deserve asylum because I'm not sure if blah, 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 right? And then you have a chance to address that blah, blah, blah in the notice of intent to deny if you have still your status. For example, you're on student status and you had asylum interview, the officer wants to deny, they'll give you this chance. So that's great. That's a great opportunity because your lawyer will provide details and response to this, and you have a second shot at the asylum through the affirmative asylum through asylum office. Now, what if that second shot doesn't work? And I'm not going to lie to you. A lot of times these officers are, bullheaded. They don't like changing their mind no matter what you throw at them. It happened to us in the past that it worked. We have this one case where we got so many expert reviews by even U.S. generals supporting that our client is going to be subject to persecution if she goes back to, I believe she's from Iraq. But, the asylum officer, we don't know what the decision, we're keeping our fingers crossed. But what I'm saying is, what if they don't? What if the officer doesn't change their mind? The asylum office still says, no, we're not going to give you asylum. And you have to understand the asylum officers, they're not necessarily immigration lawyers. They don't have legal degree. A lot of them don't. They're just college graduates, somebody who, took asylum officer training, several weeks of training. I don't know exactly. I don't want to, badmouth them because there are some asylum officers which are very thorough, very detailed, and work better than somebody who has, legal degree, law degree. But some of the asylum officers, unfortunately, they just use their gut feelings and instincts, which is not supposed to, right? So, because we're deciding the fate of somebody. somebody's family, somebody's life, and they're supposed to use the law, but a lot of times it's a human factor, the asylum officer. So let's say, anyway, go back to this scenario. They deny your case. The asylum office says, no, you don't deserve asylum, we deny your case. Well, then what happens? If you are still in current status, then you remain in your status, right? And you have this immigration court chance in your back pocket, and you already satisfied the 1-year rule, so you shouldn't worry about it. So let's say you remain in your student status, and you try to get a green card through employment, whatever, things didn't work, and at one point you say, screw it, I'm going to give up, I don't have status, I'm not going to go to school. Or you lost your status because you tried the H-1B lottery, it didn't work out, and so on. Then guess what? You have this ticket in your back pocket for your asylum. Then what you do is you file your asylum application with the asylum office again, and you notify them, I had my asylum interview, you guys denied. At that point, I didn't have status. That's why you didn't send my case to the immigration court. Send it now. I don't have my status. So now I want to use this ticket that was in my back pocket to have the judge hear my asylum case. Send it now, and they will forward it to the immigration court. So if you apply for asylum while you're in status and you have your interview while you are in status, then you have better chance of then you have better chance because you have extra shot and extra chance through asylum office and so on, and you control when you want to have the immigration court hearing, when or if or not, and that's up to you. So that's much better than anything else. All right, so I'm going to try to answer again as much as I can. I got a lot of time. I think I joined a little bit later, but let me ask Advocate Mairaj Jatol. So it's Advocate. Well, I don't know. It's kind of, it is on English program of 2 months in USA, and the institution only provide F1 visa. If visa is approved, then after 2 months, then my course complete am I eligible to stay in US? How much time? Well, after your F1 visa, you have 2 months of grace period. If you did graduate, you got a degree program, you got some level of degree, then you also have 1 year of optional practical training, OPT, where you can get work permit. If you are, if your education, your degree is in the STEM, science, technology, engineering, math, then you can also get additional 2 years, so total of 3 years of OPT, and your employer can sponsor you for H-1B. So that's how F1 students usually remain in the US. Okay, user 1905, I will ask you, I will answer your second question. You wrote, second question was, can that person who has green card based on asylum apply to Mass Health, which might be free? I mean, would it be considered as public charge for naturalization, or no issue if has green card? Yes, so asylum refugees, asylum asylees are exempt from public charge. There is no problem with public charge. Do not misrepresent answering any questions that you're a US citizen, but you can, so obviously you cannot vote and so on, but as asylee, you're exempt from public charge. So you can apply for any benefits that somebody's offering you or that you're eligible for, Medicaid, anything, food stuff, anything you have, any benefits as a refugee, because it's a humanitarian relief, you're eligible for any benefits. There is no public charge issue for asylees or refugees. Okay, O is asking, I like the name, O. Mr. Ismail, can someone from occupied country or stateless be a legitimate reason for asylum or be considered in welcome corps, or that's not enough? I need actual fear of persecution. Well, for asylum, you do need fear of persecution. Now, there is humanitarian asylum, which, you know, can be considered, and I've gotten that for my clients, where maybe there is not enough nexus, meaning connection between the protected ground for asylum, but you have suffered so much, you know, let's say you're from occupied country. Let's say you are from Crimea, which is occupied by Russia, and you've been so much harmed, you suffered such a severe harm, you know, or during the Russia's, you know, bombardment of cities and towns in Ukraine, you saw, you know, your neighbors being killed, you saw your house was collapsed, and so you suffered so much harm that for humanitarian reasons, even though you cannot demonstrate that the government of Ukraine or people in Ukraine will, cause you harm, you may still deserve asylum on humanitarian basis. So it can work on humanitarian basis. Pella is asking, how long does it take to change a restricted social security after winning asylum? What is required for it to be changed? So what is required is you need to go to the Social Security Administration office and ask them to change your social security card. They'll give you some forms. You can probably pre-prepare those forms, pre-fill it out, take it there with you. And I'm so sorry, on live stream. Okay, so it can take a couple of weeks or so. It depends on Social Security Administration, your local Social Security Administration, and so on. All right, I'll answer Chukwume, but typically about, again, a couple of weeks or so, but Social Security Administration is not. Okay, I'm sorry, it's all right. So Chukwumweka is asking, my wife and I have both affirmative and defensive asylum application in process. We have already met with an immigration judge and had a master calendar hearing. Number one, are we okay to wait that long, or can we bring the date closer? I already explained. Please watch the beginning of this live stream. I try to answer as many questions as possible, about expediting or bringing the date closer. What are the pros and cons of what? Bringing the date closer? I mean, it depends on your case. If you have a strong case, you're feeling confident, the pros are that you're going to get asylum quicker approved. What could strengthen or change our case? Credible fear before 2026. I don't understand what credible fear before 2026. There is a lot. There is a separate video. If you subscribe to our channel, or if you go into our channel, you'll see the video posted about what can make your asylum case stronger or weaker. I believe it was a short video, but there is a lot. I mean, this is a very broad question. I cannot explain to you during this live stream what are the things that can strengthen or change your case. But you have complicated. I mean, you have defensive asylum. I assume one of you has a defensive case, maybe your wife or you, and one of you has affirmative case pending. If that's the case, I mean, get a lawyer. This is not something you're going to get answered or properly answered. I don't want to give you wrong advice. I don't want to give you advice, just a random answer to make you happy, and then you're going to go and things are not going to work. This is immigration court. Immigration decides your fate, your life, your family's fate. Get a lawyer, talk to a lawyer. Don't hire me. I'm not trying to advertise myself or get you. I mean, I'm trying by the virtue of, being on social media, but for this purpose right now, answering your question, get a lawyer. That's all I can tell you is, you're not going to get proper advice, and don't rely. Even if I tell you something, don't rely on it. I mean, I'll spend 2 minutes answering your question. You don't want to, rely on this and get your entire case in immigration court for you and your family decided based on something you got from an immigration attorney, no matter how competent or how confident I feel about it. Still, don't do it. Get a one-on-one consultation, okay? Next question is, okay, so, no, my country is occupied by Israel from 1945. I don't think they'll consider it. I was born in Middle East. They don't grant citizenship for being born there. My residency expired. No health care. Okay, I understand. Yeah, you're probably from Palestine. Yeah, I mean, as I said, depends on what you suffered, depends on the basis, specifics of your case. I've represented Palestinians. I've represented Israelis from 1967. Yes, that's when the occupation took place. So 1945 was the end of the World War II. That's when Israel was formed. But so, yes, as I said, depends on your case, specifics of your case. You may deserve asylum. Depends. Some people don't understand that they have actually a basis for asylum. A lot of times I get clients, somebody who consults with me, they have, they have something happened to them, they objected to something, or somebody threatened them, caused them harm, and they don't believe that necessarily is basis for asylum, and then ends up that they do have basis for asylum, and then we handle it and we win their case and get them asylum. So what I'm trying to say is that it's best, again, this is another type of question. is very broad, very specific to your case. The answer depends on the facts of your case, and you should consult individually with immigration attorney. All right, the last, well, not the last, we have a lot of admin questions, but I have user 1905 asking again. No, well, there are a bunch of questions, user 1901. Those are from our social media accounts, part of it, which is also where they follow our videos. They're on the top of the chat. I haven't gotten to them, so I'm answering the questions by the audience first. But let me answer your question, okay? Let's not go too deep into it. Let's say the person haven't participated in military in Azerbaijan and came to USA. If the person go back to Azerbaijan as a citizen, would he be subject to military? Will he be detained at the border? So basically what you're saying is that you're an asylee and you entered the US, you got green card, and you're citizen of Azerbaijan, you evaded military service. If you go back to Azerbaijan, will you be subject to military? That's for Azerbaijan to decide. And as I understand, again, I was born and grew up in Azerbaijan. I love Azerbaijan, and I'll tell you that if you're evading military service, I don't have any sympathy to you, and I apologize for saying that. But if you go back to Azerbaijan, it will be for Azerbaijan to decide. Now, again, evading military service, I don't want you to get me wrong. If you're evading military service because Azerbaijani government is going to harm you for your political reasons or whatever that had happened to you, no, of course I do have sympathy. I've actually represented clients where oppositional members or their children who have been pressured, persecuted in Azerbaijan as part of military service, or they were threatened with abuses in the military. But, you know, I'm just saying that if that's not the case, okay, I don't want you to understand me wrong. But yes, it will be decided for Azerbaijan, and I believe Azerbaijan doesn't care, and they shouldn't care really if you're a permanent resident of USA. Now, if you become a US citizen and you're going back to Azerbaijan or any country that you got asylum from, then obviously you want to go there as a US citizen. No, not avoiding. It's late. The person came here for studying and stayed. Okay, I understand. All right, no problem. So let me answer some of the admin questions. Again, if you have any last questions you want to ask, I'll be happy to answer. Again, my name is Ismail Shahtakhtinski, and I'm the principal immigration attorney, licensed attorney in the United States. Our office is in Fairfax, near Washington, D.C. I've been practicing immigration law for more than 16 years, representing clients in immigration courts in their asylum applications, in all kinds of immigration matters, you know, family reunification, green card applications, work-based, employment-based, investor visas, and so on. If you are interested, schedule a consultation with me. You can click in the chat section in the description of the video below. And I ask you to please, if you like this video, if you found it useful, if you asked a question and found my answer useful, please press like. That's your way of saying thank you, and I appreciate it. That helps us. And subscribe to our channel. So some of the questions asked by admin: can asylum pending case seek benefits in USA with USA kids? Example, food stamps, financial assistance. Yes, I already answered that. Yes, all asylees are eligible for all the benefits that they're eligible for. There is no public charge issue. Next question, Mohammed is asking, I'm going to Mexico next month. Do you think program CBP1 will be available at that time? The answer is yes. That's what I think, but what I think doesn't matter. What matters is what will happen. You know, whether the federal courts will get to it, the Republicans will cause issues, I don't know. So the answer is yes, but I believe, my opinion is that yes, definitely next month the CBP1 will be available. But my question to you is, why are you waiting so long? I mean, if you're running from persecution, do it now, do it yesterday. Don't, you know, I mean, I understand you have family, you may have difficulties wrapping things up, but, you know, I mean, 1 month, you're thinking about next month, that's too long, you know. That's also something actually that factors in your asylum interview or asylum hearing in immigration court. You know, that becomes a factor. You know, when something happened to you, you have basis for asylum, you're already harmed, why did you spend so much time in your country before actually escaping from there? You know, you will have to provide an explanation to that. All right, I'm going to Mexico. Okay, I answered this. What's the type of sponsor you are talking about as alternative for asylum application? What do you mean? Like family member sponsor, employment sponsorship, so on. There is a separate video or actual live stream, I believe, Again, that's another reason why to go to our channel, subscribe to our YouTube channel. There is a separate video that I made specifically about alternatives to asylum application. You can view that. All right, next question is, I'm a Palestinian who was born, I believe I spoke to you. We discussed that, I believe, lie. Okay, for citizenship, even if your grandparent was born there, the issue is, okay, so we talked about this. That's pretty much it. I see there is one more new comment in the chat section. Let me clarify. I mean, the person wants to go to Azerbaijan, solve military stuff, and he worries if he detained right away at the border, he doesn't want to avoid military service. I understand. I appreciate your clarification. As I said, how Azerbaijan is going to react to it. Again, although I was born in Azerbaijan, grew up, I'm not an Azerbaijan immigration lawyer or lawyer in Azerbaijan. I cannot tell you what Azerbaijani government does. In my experience, he may be detained, he may be asked for ransom to be released. Unfortunately, Azerbaijan is autocratic regime, and there is corruption, there is stuff going on. From what I hear, it's getting better, but there are risks. So bottom line is, if he evaded military service and he is, and especially, as I said, he's asylum applicant. So, okay, all right, thank you, and have a great day. Yes, okay, user 1905, thank you for your questions. Have a great day, and have a great day, everyone. Again, please press like, please subscribe to our channel, and I appreciate you joining our live stream. Our next live stream will be next Thursday at 12:30 p.m. Eastern Standard Time, Washington, D.C. time, and I'll be happy again to answer your questions, and we'll come up with some relevant topic to talk about next Thursday. And if you know anybody who has immigration questions about immigrating into the United States, if somebody's bothering you with a bunch of questions because you are in the U.S. or you applied for asylum or for any immigration benefits in the past, feel free. Oh, I'm sorry, it's at 11:30. No, it's at 12:30 p.m. Oh, next week. I'm sorry. Thank you. Admin corrected me. Next week, it's going to be 11:30. I have a interview with my client with the USCIS at 12:30. It's a remote interview. So 11:30 is when we're going to begin next week. But all other weeks, it's 12:30. So if you know anybody who is asking you questions, bothering you with questions, obviously, if you're not an immigration attorney, you're not supposed to provide legal advice, but tell them that there is this licensed immigration attorney, U.S. immigration attorney in the United States who's been practicing immigration law, helping thousands of individuals become permanent residents or asylees in the U.S. for over 16 years. He answers all of your questions free of charge on today's Thursdays, 12:30 p.m. on live stream. Give them a link to our YouTube channel. And, if it's a Russian-speaking individual, they can contact us. They can join live streams on Tuesdays at 2 p.m. Eastern Standard Time, Washington, D.C. time. Thank you again for everyone, for whoever joined, whoever watched us, and whoever asked for great questions from us. Thank you, and have a nice rest of the week. Bye-bye.